So Dawn, we meet again.
Okay.
Hi. Now, so what are we going to discuss today?
We're going to discuss settlement agreements.
Right.
That's what we're going to discuss. I find it's something that my clients want to know about.
Yes.
Um, so we're going to just go through a range of questions about settlement agreement and
Okay.
hope it'll address many of the concerns that people come up against.
Right. Okay.
Okay. So
Yep. Yep.
I'll ask the questions
Hey, oh my goodness
and
me.
you answer,
On the
and I
spot.
will chime in. I will chime in. Okay. So
Right.
let's kick off, Ryan.
Yeah.
What is a settlement agreement?
Right. A settlement agreement is an agreement that's entered into by an employer and an employee to settle some form of dispute. So it could be an agreement to part ways for whatever reason, it could be a multitude of reasons, or it could be an agreement to settle a dispute in the sense that there's been some discrimination that the employees complained about, and then to agreement that it has numerous terms that one could negotiate.
Yeah.
They usually have a similar format. Settlement agreements can run from 2 pages to 30 pages.
Okay. Okay. So it can be pretty basic or more in depth.
Yeah, so it's once the parties have entered into that agreement,
Yeah.
either the employee either remains there, hopefully being happy that the dispute they had with their employer has been settled. Uh,
Yeah.
Settled means two things really, financially, but also what they complained about will not repeat itself, and
Okay.
or if the employer um, says bye bye and the employer wishes to go,
Yeah.
then that's it. They go their separate ways.
They part on mutually agreed terms.
Mutually agreed terms. Exactly.
Right. So next question. Why would an employer offer an employee a settlement agreement? I think you've
Right.
touched on it, but
Yeah, I have, but it is a good question. It needs to be addressed in isolation as well,
mhm.
or in its own context. It could be that things are just not working out between the employer and the employee.
Mhm.
These things happen. The employee is unhappy. The employer is unhappy with the employee, and it'll be something where the employer may say, "Look, um, it's not working out.
Yeah.
Can we agree a way that we can part on mutual terms?" And and that's usually amicable
Hmm.
because one would like to think that both parties realize it's not working out. It doesn't always work out that way, of course. Sometimes the employer has a view, but the employee doesn't see it, or the employee disagrees. So that's where you would have maybe an employer approaching the employee
Yeah.
about parting ways.
Yeah.
Yeah.
Thank you. Does an employee have to accept a settlement agreement?
No, they don't. No. It is an agreement that it's mutual.
Yeah.
Have to accept it. Normally, how it happens, how it works in practice, is that an employer, if it's the employer that approaches it, it can be the employee, but the employer approaches the subject, it'll have what's called without prejudice compensation.
Yeah.
So that will be you can't publish that discussion elsewhere. You can't tell other people about it, apart from close ones and so on, and maybe a lawyer if that person comes into play later on.
Yeah.
And what that does, that just tests the waters and see whether the employee is willing to enter in such agreement in principle. Because if the employee is not interested in principle, then that's it. That's the end of it. You
Just
can't
stops there.
stop there. Stop
Yeah.
there. And what that does by having the without prejudice conversation means the employee can't go out, leave the meeting and say, look, they tried to get rid of me and this, that, and the other, they offered me. So that's why it is without prejudice.
Yeah.
It's
But
confidential.
it's a without project. But suppose an employer um, didn't preface the meeting like that. They just said, I just want to have a discussion with you about settlement agreement. but didn't
Yeah.
put it as being without prejudice.
Yeah, that's a very good question because
Yeah.
it does happen in practice. What some employers think that by just calling in an employee and just mentioning this maybe a proposal for a settlement agreement and not mention is without prejudice can cause confusion.
Yeah.
An employee is entitled to say this is not without prejudice conversation because I didn't agree to it. You've got to agree to it. One party can't just say this is without prejudice, and the other party just goes along with it.
Yeah.
So that will entitle the employee to say this is what happened. It wasn't a protected conversation at all. Because
So the employee in essence could go out and rely on that
yeah,
conversation.
absolutely. Didn't
Okay.
agree to it. Didn't agree to it at all. Otherwise,
Okay.
anything can happen during such a conversation and you didn't agree to it. So what the employer had to say, are you happy to engage in a without prejudice conversation? Now, if the employee says yes, and fine. The employee says no, then it's not without prejudice. And that means the
Yeah.
employer might not raise things that it wanted to raise because it's not a without prejudice conversation.
But
So
they need that guardrail in order to rely on those protections that is or without
absolutely,
prejudice.
absolutely. Yes, indeed, indeed. Yeah.
Great. Thank you. So is being offered a settlement agreement the same as being dismissed or made redundant?
No, it's not. It's not.
Okay.
Because you can be dismissed for a number of reasons. For example,
Mhm.
you could be dismissed for any disciplinary, I think. Well, say just any disciplinary. You can just be dismissed even if it's not a disciplinary.
Yes,
Uh,
you can.
for example, if you got less than 2 years continuous service,
Mm.
can be fairly dismissed, providing it's not on the grounds of a characteristic. If it breaches the Equality Act, then you can't be lawful. But but dismissal is separate. It can be that you enter into an agreement, settlement agreement,
Yeah.
to part ways, which is effectively a dismissal into some degree. But in its normal sense, what you tend to think of as a dismissal being something that the employer has done to terminate the employee's contract. Same thing with a redundancy. A redundancy is, in effect, a dismissal. You're being dismissed because your job is no longer available, or your whatever you do, your role's been made redundant.
Yeah.
But we tend to view it is still a dismissal, but obviously being dismissed for disciplinary reasons is
It's completely different. Yeah.
dismissed for redundancy. Redundancy, you're innocent, you've done nothing wrong.
Yeah.
Um, disciplinary, you've alleged to have done something wrong. I had to put alleged in there because you may not have done anything wrong.
Yeah.
You challenge it, and then you see the employer was wrong to dismiss you. But no, they're different.
Okay. Great. Thanks. Um, this is a question that is always interesting, but let's go. How much money should an employee get in a settlement agreement?
Oh, how long is a piece of string? How long is a piece of string? Yeah, it's but it is a good one. It is a very good one because you see the thing is, Dawn, that many people, understandably, will think that obviously they want to get the most money,
Hmm.
employee. And it's no different from any commercial arrangement. One would assume the employee wants to pay less. The employee wants to pay less, the employee
Yeah.
wants to receive more. However, there are some statutory guidelines.
Yeah.
If you're making someone redundant, for example,
Yeah.
and you want to enter into a settlement agreement,
Mm.
um, you have to go at least by the statutory or contractual right and how much you pay someone for the redundancy. So
Yeah.
you don't just get a figure out of thin air. And what you'll then do on top of that, maybe have an ex gratia payment, or some companies have what's called an enhanced payment.
Yes.
So let's just say a statutory amount says you get £500. What an employer might do is make it more attractive and say we'll pay you £1,000, and that then the employer then decides whether or not to go for it. It's primarily a commercial decision
Yeah.
and what someone thinks they can live with. Because some people have quite attractive contracts, for
Yeah.
example. It might be that someone has 6 months' notice that the
Yeah.
employer has to give them. Well, that might be quite attractive to them because it means they get 6 months' pay plus something else, holiday pay and everything else, and hopefully you can get themselves a job within that time, within the 6 months. If you've got just 2 weeks' notice, then You know,
Yeah.
that's just too short. But that's what, that's what you're entitled to. That's what you're entitled to. So it depends on the circumstances, you know.
And I know for some of my clients, they struggle with that. So they struggle with the issue that they're grappling with.
Yeah.
So that's in and of itself, that's sometimes challenging. And then
Yeah.
they have to think about financially, what does this mean? And all kinds of emotions can come
Yes.
into play, especially if the employer hasn't behaved pretty well.
Yeah.
I
Yeah.
always say, just like you said, look at what your package is,
Yes.
get a clear understanding of what your, not your salary, but your whole package, because you have to know that you're not just giving up a salary, you're giving up a whole package. So what is in reality, the value of your whole package,
Yes.
including notice terms and including how long would it take you to get a job?
Yes.
And yeah, and kind of like use those objective metrics
Yeah. Yeah. Yeah.
as a
Yeah.
starting point.
Yes. Oh, yes, indeed.
Yeah.
Indeed. And you have to be realistic as well. So yes,
Yeah.
that's a starting position.
Yeah.
And then you see what add-ons you can get if you
Yeah.
can. If you
Yeah.
um, because there might be, for example, a situation where there's discrimination.
Mm.
There are judicial guidelines on what you can get. So, if someone were to say that I've been discriminated against, and I want £1 million because of someone acting in a discriminatory way, you are not going to get it.
Ah.
As that. You just will not get it. There are guidelines. It's the guidelines we use are something called Vento
Yeah.
guidelines, and that tells you what it is. So when you see the headlines of these big awards that someone gets, it's not the injury to feelings part, I've been discriminated against.
No.
What it is, it's an element of that plus your loss of salary.
Yeah.
How many, if you're of a senior age, as it were,
Yeah.
and you've been working in one sector for a long time, and you've got, say, 4 years to a retirement, you're not going to get a job within the sector again. So what you may get is 4 years loss of salary.
Yeah.
That's what that big money's about. The big money is not about a discriminatory thing. It's the consequences of being discriminated against. You've lost your job. That's what you see. So yes, you're right. The starting position is, what can I get? My
Yeah.
notice period is 6 months. I'm entitled to 6 months pay. I'm entitled to my holiday pay and whatever else. And
Yeah.
then what extra can I get for what I've suffered?
And sometimes those big payments actually relate to pensions.
Yeah, absolutely. Yes. Oh,
So,
yeah. It's a package.
yeah, if you think about the case Hastings versus King's College Hospital,
Yeah.
um, just like you said, the injury to feelings um, award was insignificant. I'm not saying that
No,
it
no.
actually wasn't, but compared to what he got for loss of his pension, they
Yeah,
had to they had to kind of like put him back in a position as though they'd never damaged him.
absolutely.
It was absolutely, it was eye watering. And I know, like when I'm training, um, and I mention his case,
Yeah.
employees are always stunned. So
Yes.
employers need to be watchful of those generous pension schemes.
Absolutely. It's part of the package. It's part of
Yeah,
the package. Yes, indeed.
yeah.
Indeed.
Okay.
Yeah. Yeah.
Thanks for that.
Mm.
Okay. Is the settlement payment tax free? Whatever
It can be, yeah,
yeah.
up to 30,000. So what we tend to do, we tend to use the rule of thumb is up to £30,000, but that's not strictly speaking
Okay.
correct, because if it's purely like I know your notice period or payment in lieu of notice, then effectively what you're doing, that wage you're getting, your notice period pays your wage, so you can't really get that tax free, because that's all you're getting is your wage in advance. So it's
Yeah.
still wages, so you still got to pay your tax on top of that. But if you're paying um, damages for, say, injury to feelings, discriminatory act, and ex gratia payment, then up to £30,000 is normally, and I have to caveat, to qualify that, normally tax free.
Yeah. But the contractual stuff is subject to tax.
Yes, it all depends on what we say, what the heads of claim it comes under. If
Yeah.
it's say if it's just notice pay, then no, not really, because that's just your wages. That's, yeah, and
Yeah.
you pay tax on your wages.
Yeah.
But other things, then the rule of thumb is up to 30K. You're okay.
Okay. Thank you for that. Um, I think you've answered this, but let's go with it. Should
Yeah.
an employee still get holiday pay, bonuses, and their notice pay?
Absolutely, absolutely. I mean, the bonuses is always it's
Mhm.
always one you've got to look at very carefully
Yeah,
because the chances are, well, not chances are, but bonuses are discretionary. There
yeah,
is some feel they're not, but they are discretionary, and a lot of employers will have it that you're only entitled to a bonus payment if you're in employment at a certain date.
yeah,
You could imagine if you've got to be employed between, say, the 1st of January and the 31st of December, and the parties agree to part ways on the 1st of December, you're thinking, well, come on, I've worked for 11/12 of the year. I should be entitled. So I would expect one to negotiate a settlement taking into account they
yeah,
have worked for most of that year.
yeah,
But yes, you should be, as you quite rightly said, you should be put into the position that you would have been had whatever that dispute you've got didn't happen. You shouldn't really be suffering the consequence of it. And if that's what you would have got, you should get it.
yeah. And
Yes.
it's really just thinking that and thinking, sitting down and thinking objectively, not
Yes.
emotionally,
Yeah.
and almost putting it in boxes. What am I entitled to? And
Yes.
taking all your emotions out and saying, actually, what is it that I need to live?
Yeah, absolutely. Absolutely. Yes.
Maintain my standard of living
Yeah.
and take the time to get another job if I need to.
Yes. Yeah.
Because so often employees kind of like mix that in with their emotions. And
Yeah.
that's where it goes off. It's like, I need to make my employer pay,
Yeah. Yeah.
you
Yeah.
know, and I need to
Yeah.
make them pay for what I'm feeling and what they've done to me.
Yeah.
And that kind of like takes them down a rabbit hole. That's often not helpful.
No, it's not. It's not because even if you go to the employment tribunal,
Yeah.
and if you were to succeed, what
Yeah.
the tribunal is going to do is compensate you for your losses. They're
Yeah.
not going to give you money to punish the employer. It doesn't work that way. It's not punishing the employer. It's your losses you're getting for.
Yeah.
'Cause if you are going to be punishing the employer, as you
That's
could
it.
well imagine, most a lot of employees would think their case is a worse in English legal history.
Yeah.
They treat me that way. So they'll be asking for millions.
Yeah.
So it doesn't
Without a
work
doubt.
that way. You can only get your losses that you've incurred because of the discriminatory act, and
Yeah.
the law will compensate you for that. It will not punish the employer. Will never punish the employer. Never, never.
Something that's just popped into my mind, okay, but when people are negotiating,
Mm,
they couldn't actually negotiate access to an employee support scheme,
mm.
couldn't they? And coaching.
No, I mean, what you do, what you're supposed to do
Yeah,
with settlement agreements, you're supposed to have an independent advisor. um,
yeah,
and you must to get it as
yeah,
an agreement. So, and the law stipulates who that independent advisor can be. So you can have anyone helping you, but when
yeah,
it comes to that final advice, you
yeah,
must go to an independent advisor because what the employer doesn't want um, is that the employee says, I didn't get independent legal advice. I didn't know what I was signing. I didn't know what
yeah.
I didn't know what I was doing. So that's why it's important you get that advice.
And
The-
can you define independent legal advice for
right. So a
listeners?
barrister, a,
Barrister?
a solicitor,
Yeah,
a trade union organization representative can be an independent advisor.
yeah,
So people come to me, and I will then, what will happen is that I provide what's called a certificate to
yeah,
say that I've advised this person. We're named in the settlement agreement. I have advised this person, obviously advised them on their rights and everything else. I may have been part of the negotiation process. I may not. Uh,
hmm,
and therefore I confirm that I have a certificate of insurance in case anything goes wrong later on, which is very nice and then reassuring. And then I sign it off. So I sign my certificate part, And then the employee will sign their part, and the employer sign their part. So that's how it works. That's how it
An
works.
employer always pays that fee.
Right. Well, yeah, that's
Okay,
some misunderstanding there.
okay, go on.
No, no. So it goes back to the answer that I gave just now, that the employer doesn't want the employee to say they couldn't afford to obtain
Yeah.
independent legal advice. So what employees do, they contribute. They don't pay for it,
Ah,
contribute to the legal what they say is a reasonable sum. Although I can tell you reasonable sums vary from one employer to the next, but a reasonable sum to what, and so because what they don't want an employee and
ah,
sorry, a lawyer to say, well, look, here's my bill for 5 grand for going
yeah.
through this. So they'll give a reasonable sum. It varies. My practice is, and
Mm,
this is ridiculously low, is that I would normally just accept what the employer um, offers to pay. So,
yeah.
and I would normally do that. I don't want people to see this and think, oh, right, we just get our employee to put £50 and he's trying to go spend hours and end going through this. But so that's what I tend to do, so that my client's not out of pocket.
Yeah.
In a,
Typically, in my experience,
mm,
employers pay 300-400 pounds.
yes,
That's in my experience what they pay. So around that figure. The
yeah.
last one I did was about that I know of anyway. That I consciously know that an employer paid was I think was about 450.
Yeah, yeah, indeed, indeed. Yes,
Yeah.
it is around that sum. And what will happen? And it swings around about some settlement agreements you put more time into it than others.
Yes.
Often, often when someone comes to me,
Yeah.
they've got they've agreed a figure in principle with their employer. Often,
Yeah.
not always. Some they come to me and they want more. We'll always want more.
So the figure being the legal.
No, sorry, no, it's not. It's a sum that they've agreed for. Let's just say, for example, part ways, and
Okay.
they're happy. So they've agreed those sums, and then what I've got to do is then advise them on the terms,
Yeah.
because there are some terms you need to flag up. It's confidential. You can't defame the employer and those kind of things. Make sure they know about that. Return the employer's property and all that kind of thing. If you
Yeah.
do it, going to be in breach of contract, and then the employer can come after you.
Yeah.
So so that makes it a little bit easier. Of course,
Yeah.
when I'm negotiating, however, then
Mm.
obviously I'm spending more time on it.
Yes.
Um,
Yeah.
but I still try and do it within the sum, of
Yeah.
I'd like to think that when an employee comes to me
Mm.
with a draft settlement agreement, they've had some discussion about the amount the employer is going to pay them, because they wouldn't come to me in the first place.
No.
If the employer says, I'm going to pay you £50, and in fact they're entitled to £1,000, why are you coming to me and say, this sum is unacceptable? You can tell the employer that yourself.
Yeah.
So it's
Charge.
yeah. Sorry? And,
Just
yeah,
charge.
absolutely. So,
Okay.
I'd say 90% of the time it's done and dusted. I've
Yeah.
just got to do my part. There's sometimes though it can be lengthy. Can be,
Yeah.
yeah.
Yeah. Having managed some cases, I can understand how that could be.
Yeah. And what's often a difficult thing for someone in
Yeah.
my position is that when an employee comes to me to
Yeah.
settle an agreement, there is a presumption that there will be an agreement.
Mm.
So, because the employee is perfectly entitled to say, you know what, Ryan, you've advised me, and I'm not going to enter into this agreement. I'm
Mm.
not going to do it. I don't think it's fair. They've offered me £1,000. I want £2,000. They're not budging on that. I'm not going to enter into it. Now we're in a different thing now. I'm out of this picture.
Yeah.
The question is, um, have I done my bit to be paid under the settlement agreement? Because there is no agreement. I just advise under it. So there is that tricky part, but I've got to act professionally anyway,
Yeah.
and then see what happens. But just to complete that part about the employer paying for it, I will then invoice the employer.
Yeah.
Then the employer pays the sum that they've put in the agreement.
Okay. Great.
So
Thank you.
yeah.
So, what rights would an employee be giving up if they sign a settlement agreement?
Oh my goodness me. Yes.
We need a list.
Very good. Very good. I tell you what, they give up almost everything apart from a few things they can't give up in law. For example, you can't compromise something to do with whistleblowing, and you
Sorry, can you just repeat that again?
can't compromise something to do with whistleblowing.
Yeah. Okay.
So in other words, you can't enter into an agreement,
Yeah.
say I will not whistleblow about the wrongdoing I've witnessed.
Mm.
That would be against public policy. That
Yeah.
means, you can work for an employer who's doing illegal things. They know you know that.
Yeah.
Compromise that by entering the settlement agreement. There is some big news about some illegal acts going. You know about it. You can't talk about it. So
Yeah.
you can't compromise that. You can't compromise your pension rights as well. You can't.
Okay.
So in other words, you owe something. You owe something. You can't
Yeah.
be cut short on that. Um, but otherwise, you are effectively giving up everything. Um, there was an interesting case some time ago from the EAT, the Employment Appeal Tribunal, where someone entered into an agreement waiving their rights to pursue future claims against the employer. And then something came to light that they didn't know at the time that they settled they entered in a settlement agreement, and they could not have known. Not just they didn't know, they could not have reasonably have known.
Yeah.
And so the legal question was, did that person compromise? Did they settle that part when a claim that they didn't know about? And the court said no, they didn't. If they didn't know about it and could not have known about it,
Oh,
then it doesn't fall under the settlement agreement.
okay.
So you're effectively settling everything that you know
Yeah.
and could reasonably have known about at
Oh.
that date you enter into the agreement.
That's a really important distinction that you could
Yes.
really have known about.
Yeah, absolutely. Because you can
Yeah.
have a situation where you enter into a settlement agreement today,
Yeah.
and then tomorrow the employer discriminates against you. Now, and you've left. So the question will be, well, how can that happen? Well, it can happen, for example, prospective employer
Yeah.
asks for a reference.
Ah.
And, and then you write a really negative reference that you would not have written
Yeah.
um, in other circumstances. And you can't say the employer can't say, well, you compromise it. I can do what I like now. I can just defame you. I can call you this, that, and the other. There's nothing you can do. No, that'll be wrong.
That's fallen outside.
That's what outside, exactly outside. So yes, the employee can bring, well, the former employee can
Yeah.
bring a claim, can bring a claim.
And
Yeah.
just while also on that point, if people are settling, they got entering into a settlement agreement, it also makes sense for them to agree an employment reference as part of that.
Oh yes.
Doesn't it?
It does. It does.
Yeah.
Things have changed. Things have changed from when I first came to the bar because, you used to have opinions about employees, former employees, as part of a reference.
Yeah.
Someone's been a great worker, always punctual, they this, that, and the other. And then the question will be, well, why are you getting rid of this person if that's the case, or what have you? Nowadays, you're getting factual references
Yeah.
because employees don't want to be sued in any way by
Yeah.
the employer or the prospective employer, for that matter, which
Yeah.
can happen in negligence. So you normally get factual references, started on this date, finished on that date, did this in between. What in between means that's the job title.
Yeah.
Don't get very much, but sometimes you do. And when you do get something, you are absolutely right. If you can agree, well, you should try and agree a reference.
Yeah. I've
And
had an instance where somebody's employer told them to write what you want us to say.
goodness, goodness
They
me.
did. They did. And another instance where the employer and the employee agreed between them.
Yes.
So it went back and forth for a while, and then they settled on something that both parties. were happy with.
Yeah, the latter is the best way. The former is very dangerous.
Yeah.
Because one would like to think that an employee would always write a glowing reference, and it may be a reflection of their ability in themselves. It may be.
Yeah.
But let's just say that the employee doesn't truly share what the employee has written.
Yeah.
But you told the employee to write a reference about themselves, so they did.
Yeah.
And they send that to the employer, then sends that to a prospective employer. And let's just say there's an issue later on with that employee after they've employed them, and the
Mm.
new employer goes back and says, "But you wrote all these wonderful things about." Yeah, it'd be quite embarrassing for the employer to say,
Yeah.
"Well, we didn't write it."
Yeah.
No,
And
that
the potential liability as well, depending on what that individual does
yes,
at a new organization.
absolutely, absolutely. There is. So you do owe a duty of care
Yeah.
to the subject of the reference,
Yeah.
i.e., the former employee, but you also owe a duty of care to the recipient, prospective employee.
Yeah. Yeah.
You write something that is glowing, is just not true,
Yeah.
then it is a form of negligence,
Yeah.
because you know that that prospective employer is relying on the statement you have made within that
Mhm.
reference. But for that, they may not have employed that person.
Yeah.
They've relied on what you've written in the reference, they've employed the person, and what you wrote in that reference was false.
Yeah.
If it's false, they can come after you for their losses.
Yeah.
So employers, beware.
Yeah. And I remember having these discussions, and I worked in a really, really good HR team. And I remember having these discussions about, okay, what should we put in this reference, especially when it was a challenging issue.
Yeah,
What do we put in this reference? We know that it's got to be factual. We know it's got to be true,
yeah,
but there's still a fine balancing act. And sometimes we only got the legal advice on it just to make sure that whatever we were putting out wasn't going to come back and bite us, essentially.
yeah, yeah, yeah,
The other issue that I think, yes, you can have factual references, and many employers says, start, finished, the job.
yeah.
That's it.
Yeah.
I think there's more of a challenge when you're working like in a regulated profession, like a nurse or a doctor, and that, or any other regulated profession, it could be finances. And if there's a fraud issue, what happens if that person is dismissed from fraud
Yeah.
and they're reported to their regulatory body, for example, then the reference would surely have to say that factually.
Yeah, yeah. I mean, it would, because you know that's a vital piece of information.
Yeah.
Effective employer will need to know. They will
Mm,
need to know. Um, there could be a thin line between an employee who's facing disciplinary proceedings and then decide to resign before it's concluded. There's a thin line on whether or not the employer can mention they were going through something. That's really up to them. But when you've got something, especially like, in finance, for example,
yeah.
a person was, dismissed or investigated, or even in the educational caring sector, and some with safeguarding, you've got to mention it. You've got
Yeah.
be very dangerous and not to just give a straightforward factual. But with a reference, people tend to get confused about this. They didn't say an employer can't write a bad reference. An employer can write a bad reference if it's fair, true, and accurate.
Yeah.
Yeah, they don't have to go out and say you're the most wonderful person ever if you're not.
Yeah.
So as long as it's fair and accurate, then if that equates to what bad means,
Yeah.
so be it. So
Yeah.
there's no duty to have to write a good reference.
Okay, great. Thank you. And what happens while we're still on this point, because I'm just thinking, what happens if someone um, resigns, for example,
Yeah,
or leaves and they would otherwise have been subject to a formal
yeah,
process?
yeah. That is a thin line. You know what? It's a good question. I think it depends on the nature,
Yeah.
the allegation, the nature of the allegation that led to the disciplinary proceedings. For example, if it's a safeguarding issue, I think you've got to mention it.
Yes.
It's not because, you know, we would know, it's not always the case, but we would know that someone jumped before they were pushed. Now,
Okay.
if you've been working at a school, say for example, in a care home for 20 years, you're going through these disciplinary proceedings and safeguarding, and you decide you've got a letter this morning saying that there's been an investigation and it's been recommended it goes for a disciplinary hearing. You got a letter this morning, and then you decide, you know what, I'm going to resign today with immediate effect.
Yeah.
One might say, there's no smoke without fire
Yeah.
because why? Why are you doing this now?
Yeah. Yeah.
It might be you feel you're being hard done by. Yeah, I get that. I get that.
Yeah.
But there's be a bit suspicious, I think. So I think some things, if some things you can probably just get away, but when it comes to gross misconduct, I think you've got to be, yeah, you resign, but you've only resigned before you were pushed. And I think an employer might have to then mention they were subject to disciplinary
Yeah.
proceedings,
Yeah.
but um, but resign because you can have the absurd position as well when you've had the disciplinary hearing, and let's just say the person, the disciplinary officer says, let's say what's today? Today's Tuesday, and the disciplinary officer says, well, I'll let you know by Thursday, and they
Mm.
resign on Wednesday. Or I mean, that will mean that they can't record that at all. That would be that wouldn't be right. It wouldn't be right
Yeah.
in my view.
Yeah.
Right.
Yeah. I
Yeah.
agree.
Yeah.
Thank you. How long does an employee have to consider a settlement agreement once it's put to them?
Right. Um, yeah. Now, some employers give them a really tight thing. So, for example, today's Tuesday. They say, well, I need to know by Friday.
Yeah.
Now, it's got to be reasonable because
Yeah.
bear in mind that you've got to get an independent advisor. You may not get someone that quickly. You
Yeah.
know, and I'm not always available. If someone wants to instruct me, it could take like 2 weeks. Solicitors could take the same, could be, less. Depends on on their workload. So what often happens is that an employer will give a deadline to see whether the employee agrees with it in principle, as opposed to the terms of the agreement.
Yeah.
In other words, they say, look, because if you're not in agreement in principle, if you're not in agreement to leaving or what have you, then there's no point in waiting 2 weeks to do that. You ought to know in a short space of time. So what will happen? They'll say, look, give us 3 days to say if you agree to, in principle, to enter into a settlement agreement. If you then say yes, then they'll get you the draft terms. It'll come from the employer. It won't
Yeah.
come.
That normally comes through pretty quickly.
Yeah, absolutely. And then you have time to get an appointment with your independent advisor and
Yeah.
be advised properly.
Yeah.
So it is one of those things, how long's a piece of string, but you should never be hurried into it.
Yeah.
I
I think
think,
that's the key. And I think 5 working days, setting aside people's availability,
yeah,
I think it's reasonable to give the employee 5 working days to consider it because especially they've got so much going on.
yes,
And you've got to avoid that hint of trying to push making it look like you're pushing someone out of the door,
yeah,
or
yeah,
there's that coercive element to it.
yeah. Indeed,
Yeah,
indeed. But the employer should be in a position to satisfy itself.
yeah,
The employee has considered this carefully.
yeah,
And that's what the employee wants to do.
yeah,
Have it in later on being properly advised. You don't want to be a rush. There's nothing worse, and I think,
yeah,
than if an employee says, "Gosh, I've done this. What on earth have I done?" And it's all gone by and raced by, and they signed their life away. No, you
yeah.
don't want that. You don't want that.
Because in some instances, to be fair, people are signing over um, significant employee packages. They're not things that you can just. Well, you shouldn't just say, "Well, okay, I just want to go." You've
Yeah,
got to know exactly what you're giving up and being able to make an informed decision. But you have to have informed thinking first before you can make an informed decision.
absolutely,
Yeah,
absolutely. Because sometimes you don't even know what your rights are.
yeah,
Take for example the question you raised earlier on about the bonus.
mm,
Um, it might be you signed away receiving a significant bonus. whereas contractually you would have been entitled to it, or at least in a good argument for it.
Yeah.
So,
But when you think about it, if you're out of work,
yeah,
3 months' money can make a significant difference.
yeah,
And
absolutely.
even for those people that are fit enough to go for another job, depending on the circumstances that they leave their employer,
Yeah.
some people they need that. They've been damaged mentally.
You're right. And these are sometimes factors that not so much from employees, but from employers do not take into account.
Yeah,
It's not simply a case, as you say, just paying X amount of weeks or months.
yeah,
If someone's been hurt badly, been discriminated against, and I'm not just talking about under the Equality Act, being treated detrimentally for whistleblowing, for example,
yeah,
there will be an effect. And sometimes people are psychologically damaged by the way they've been treated. So you have loss of confidence.
yeah,
Also, you can't even get out of bed to go and look for another job. You're fearful of what you've experienced, you're going to experience again.
yeah,
So it does take a while sometimes for people to get themselves out of bed and go out and in to seek for a look for another job. It's not simply a case that you've been you parted ways on a Friday and Monday you think, ah, jolly, I can just go for a job. No, it's not always that way at all. It's not that way. You
and some
definitely
employees don't realise how badly they've been affected
no.
because they've been in this fight for so long
Yeah, yeah, yeah.
that they've been and it's only when they step back that they realise actually I've been damaged here and I really need to go and get some help.
Absolutely, absolutely. Yeah, it becomes familiar what the way you've been treated, and you just don't know that you're in it,
Yeah,
out of it. To some degree, it's not going to be worse than when you're in it, but you reflect and think, gosh, I didn't know that. There was gaslighting. I didn't even know. I didn't know all these things were happening to me. Every time I raised something, they were making me think it was my fault, or
yes,
I didn't really hear this. I didn't witness this. It is then you realize there's gaslighting. There's this, there's that, and the other. Sometimes you don't realize until afterwards when you talk to a former colleague and said, well, yeah, we were treated this way, weren't we? And they say, no, I wasn't. I was fine. Really? So it was just me. You just
yeah.
say it, and then that's even yeah,
You've got to
psychology.
make allowances for that as well. And even if your employer doesn't, you've got to think about that in a balanced way. And because you're not going to get exorbitant amounts,
No, no,
you're going
no.
to have to think about what you need to recover and being able to present that in a persuasive way.
Absolutely,
Yeah,
absolutely. So that
yeah,
you are properly and reasonably compensated for um, within what the law allows you to get.
yeah.
I have to put it that way because, like I said, you're probably never really fully compensated. I mean,
No,
how can someone be compensated in monetary terms for psychological damage? You
no.
can't really, that doesn't do anything. But that's the best we can do. All,
Yeah,
all an employment tribunal can do is to award compensation and some other things, but they can't make you better.
no, no,
So, it's
no,
the
they
best
can't.
money, the best money can do. Yeah.
Just on one point about um, going back to negotiating a package, as it were, or thinking about what is in your package.
Yeah.
There's just one thing that came up in my mind, and that's shares.
Oh my goodness me. Right. You know what?
Because some of those, I've had a client where she was literally sitting on so like realizing the shares right at that crucial moment.
Hmm. Right. You know what? I think, Dawn, we're going to have a part three on this. And I tell you why. I tell you why. Because
Okay,
I am involved in a case
all
as
right.
we speak, and we are awaiting the judgment of that case.
Okay,
Issue of shares is
yeah,
central to that case, which means it will probably go further. I can say no more. So I don't want to give an opinion yet,
no, that's
but
fine.
it will come out. It is central. It's a brilliant question.
Okay, we're going to
So
go back to shares.
yeah, we'll come. Yeah, so the decision's coming out is due at any time. Well, not any time now, but next couple of weeks.
Yeah, but you can imagine if someone's in that position and
Yeah,
they've got, in addition to the normal package, as it were,
yeah,
right, or whatever is normal, for their industry, they
Yeah.
also have a pretty significant share package
Yes.
on the
Yes.
line, which actually may be worth more than their salary for the year, for example. But we'll come back to that. I hear you, right?
What I can say is
Yeah,
that because my case is slightly different. It's well, I won't say any more than that. But what I can say from a general perspective,
yeah,
if your shares, if your entitlement to shares
yeah,
is based on your contract of employment, you have these share schemes, then
yeah,
then as you quite rightly say, the value of shares
mm,
can be more than the person's salary.
yeah,
Just could you imagine if there was an, I don't know, Apple UK, that you had shares of
mm,
many years ago, and now you got Apple being, probably most valuable company in the world, and
yeah,
those shares be worth quite a lot of money, more
yeah.
than what you're probably earning. So yeah, so you will be entitled to your shares. Something you have to look at. Uh,
I think we've covered why the employer requires legal advice and the legal fees element.
yeah.
Um, can they talk about the settlement agreement with their friends or family?
Right. Not with their friends, with close relatives.
Yeah,
Obviously, the lawyer knows about it, and
yeah,
some organizations they can do. For example, HMRC, for example, uh,
yeah,
so they can, and a judge can order that it be looked at by a third party,
yeah,
depending what what's significant about it. Otherwise, you can have a situation where someone pays um, they're supposed to pay tax under the settlement agreement and they don't. And then so HMRC needs to look at that. But close relatives
yeah,
and so on, yes. I mean, I often say that uh, you know your partner, maybe your parents, if they need to know,
yeah,
that's it. No
yeah.
more, no more. Because what you want to do is to have control of that circle. Because what
Mhm.
you don't want is to tell too many people that you think are close
Yeah,
and they tell other people, because that can make you be in breach of contract. And
yeah,
breach of contract means pay that money back and
yeah.
more whatever damages. So you don't want to put yourself in that position.
No, but you also want to be making sure that you're getting your speak. Obviously, if you're married or you've got a significant other, and
Yeah.
it's going to have an impact on them. But
Yes. Yeah. And that's fine. That's fine. And
yeah,
actually your agreement says that you can tell them. But that's it. That's it. And they're going to be bound by terms as well. So in other words, they can't, where it says that you can't defame the company, they can't do it either.
okay.
Do they know? In case
Can't come out fighting on your
you
behalf.
can't do that, you can't do that. No, not at all. And you know what, Dawn, you say that, but sometimes that's quite frustrating to some people
Yeah,
because when they've entered into a settlement agreement, yeah, they've been paid some money, but they also think they've been gagged. And they
yeah,
can't tell anyone what they've gone through. It stops now.
yeah,
So the most they can say when someone knows something about what's going on is just say that we've reached a settlement, an amicable settlement, and that's it.
yeah.
But some people want to tell their story and they can't. So if you want to tell your story, then I don't enter into the settlement
That
agreement,
was
or
yeah.
enter into the settlement agreement with a term saying you can tell your story, which I doubt very much many employers are going.
No, I don't. Yeah, they're
No, they're not going to do that. They're not going to
not
do.
in it for us.
No, they're not going to pay you money for you to go and tell them how bad they were. No, that's not going
And
to happen.
potentially sell your story.
Absolutely. Precisely. Precisely. So if you think you can sell your story for more you're going to get under the settlement agreement, then that's a commercial decision you have to make. But
Yeah. And just before I go to the last question, it's just getting employees concentrated on the fact that it's what you will get compensated under the law,
yes,
rather than an emotionally driven decision. It
absolutely.
is in many respects an objective measurement, isn't it?
It is, it is. But as as um as lawyers who specialize in this, we obviously know what the tribunals are awarding for
Yeah,
certain cases.
yeah,
So so hopefully, having been advised, an employee having been advised,
Mm.
they would take that on board
Yeah,
and say, look, yeah, I think I'm worth more, but I hear what you say.
yeah,
For we know what tribunals can award for certain types of cases. Like I said, if you talk about discrimination, talk about Vento, the
yeah,
court gives guidelines every year. Every 6th of April, there's a new guideline.
yeah,
The boundaries are the lower band, there's a middle band, there's an upper band, there's a band, although it's called upper band, there's a band even above that. Um, and so you can't come out and say I'm going to get £100,000 for injury to feelings. It's not there. Wait, exceptionally, you've got to have something really, really exceptional to get that kind of money. So it is within that legal framework,
yeah,
not what you feel you're entitled to due to your emotions.
yeah.
Doesn't work that
I
way.
agree. And I've only known one instance where somebody negotiated a very generous
Mm,
settlement agreement. And that is because their employer really put their foot in it.
yeah,
They had publicly documented evidence.
right,
So
right.
they were, in other words, they were in a very strong negotiating position.
Yeah.
And that rarely happens.
Oh yeah.
So it pretty much really happens. And, they wanted to part ways, so they made it work.
Yes, yeah, yes,
Um,
yes, yes.
and I suppose I say that to say this, that an employer really needs to have a really strong incentive, a strong motivation if they're going to negotiate over and above. It really has to make commercial sense. Like, well, actually, give them 50 grand,
Yeah.
or 60 grand, because just to get us to the door of the tribunal, we're already into half of that. Because I don't know how much barristers cost these days.
Oh, I'm cheap.
Yeah. I remember when I used to manage bundles.
Okay.
And so, once it was ready to go to tribunal, they would send through three names of a barrister.
Yeah,
And
yes.
I think it was 400-ish at the time. Then it went to five, maybe six. Then you had 1,000. So there was three bands. It's a lot more now.
Yes, yes,
It's a
yes,
lot
yes.
more.
Yes, yes. I mean, obviously I'm not here to defend my
No,
learning,
no, no. But
I think
you guys are at the top of your profession, so I'm not saying anything.
no, I know,
About,
I know.
I'm just saying it's
Yeah,
not cheap. So
no,
the employer
indeed.
might look at all those costs.
Absolutely. It's not cheap. And what it is, and the amount of times I hear these from clients, they
Yeah.
say, wow, I didn't appreciate the amount of work you did before we went into court.
Yes.
Although the day rate seems high, you've done about 80% of that work before you get there. You're reading volumes and volumes. I was yeah, I was in July for 10 days and
Yeah.
was reading papers. I mean, I enjoyed the sunshine on the Greek island. I'm not saying I didn't. It had to be, it would have been rude not to. But I still had papers with me
Yeah.
reading because I had a big case coming up about 3 weeks after that. And I
Yeah.
just couldn't afford the luxury of being out there for 10 days and not even pick up the papers. So I
Yeah.
read. So these are things you have to do. So a lot of the work is done beforehand.
Yeah.
And the
And I
rest,
think even when I'm doing a 1 hour call,
yeah,
once I put down the phone, I might spend another hour thinking about writing up the notes. So yeah, I get it.
absolutely.
And
Yeah,
thinking about what someone said
yeah,
and what
yeah,
the next steps are.
yeah, absolutely. Absolutely. So yes, yes.
So very last question.
Yeah.
Um, what happens if an employee changes their mind after they've signed a settlement agreement?
Oh, too late, too late. Yeah, so a
Done
settlement
deal.
agreement is a contract. It is a
Yeah,
contract. And it's no different from any other contract you enter into.
yeah,
You book a flight to go to abroad. You check,
yeah,
I don't want to go anymore. Tough. The airline's not give you back the ticket
yeah,
unless it was covered under some insurance that there's a problem some way. So it's not really you just making a voluntary decision not to go. There's something's happened. But otherwise, that's it. It is a binding contract.
yeah,
An agreement is just another word for a contract.
yeah.
So too late. So that's why make sure that when you sign on that dotted line, that's what you want. There's no turning back. No
So you've negotiated,
Yeah.
you've accepted in principle
Yeah.
that you speak to your lawyer or barrister or
Yeah.
whoever you are, and you're having those discussions before you sign.
Yes.
If you've got any misgivings, you're actually putting them on a table before you actually sign.
Yeah.
Yeah.
Yeah. Yeah. You've got to. And it's important to know that the independent advisor is an advisor.
Yes.
You have
Okay.
to accept it. You
Yeah.
don't have to accept it. You
Yeah.
know, just advise. You know, if I say to someone, in my view, that's a good settlement because, you know, if you go to an employment tribunal, you're going to incur costs in paying for a lawyer. It's very stressful,
Mm. Mm-hmm.
extremely stressful. And if you were to win everything you're asking for, doesn't always happen,
Yeah.
the tribunal can only award you X amount.
Yeah.
Well, what you're being offered is X minus Y, but it's 80% of what you would get. Why go
Yeah.
for that trouble, this, that, and the other? It's
Yeah.
up to you. If you don't say, no, I want to go to court and tell the world how bad, you know, my employer's been,
Yeah.
it's your choice. That's your
And
choice.
typically, when people are in that mindset, they become pretty ineffectual anyway because they're blinded by emotions rather than
Absolutely.
the facts.
Absolutely. What I can say, you know, is that the employment tribunal is not interested in you going to have your say in court.
Yeah.
They have cases every day. What they want to do is hear the facts. Have you proven your case on the balance of probabilities or whatever it is? And that's it. If you haven't, you know, you've lost your case. If you don't,
Yeah.
they're not going to be thinking, "Wow, great, you've had your say. Thank you for coming here and telling us." They're not
Yeah.
they're not interested. They
Yeah.
just go to, you know, to referee a dispute. That's all they're there
Yeah.
to do.
Yeah.
And then move on to the next case. Simple as that. Simple as that.
And I think that's, thank you, Ryan. I think that's really useful for people to know. Um, you know, think about your state of mind before you're going to an employment tribunal and
Yes.
your motivations for going because it is going to cost you on so many levels.
Absolutely. Absolutely.
Well, that's the end of our questions for
Wow, thank you very much. Thank you. Thank you.